We have today an event that we are organizing together with ICLE, the International Center for Competition, for Law and Economics. Law school is a weird law school because we have business and economics in our blood, and we thought it would be a good opportunity, given that some people were around, not only some people, as I will explain briefly, that could teach us something about the role of economics in competition law enforcement. And Cento Veljanovsky, he's a well-known scholar, professional. Well, you can search online about him. He has done tons of things. And he's nowadays involved in many cases in private enforcement of competition law and damages claims. So we're going to listen some of his reflections about what has happened, mainly in the UK, but which may be also useful for other jurisdictions, about the use of econometrics for calculating the amount of damages, the overcharging in case of cartels. At the same time, these days we had here Jeffrey Money, who's he's not an economist, he's a lawyer, but somehow, I don't know why, I think he has economics in his blood and definitely in his genes. But he's a lawyer. And he's the president of ICLE, and he teaches here competition law in IE Law School. Very smart guy. As you can see in a minute, he's not going to talk about private enforcement of competition law. He's going to talk about, although he could, but he's going to talk about the role of economics in competition law enforcement, and how economics should inform the design and the enforcement of legal rules. And that's going to be, I think, very interesting. And as the moderator, Lazar and myself picked Sabrina Pekarovic, which she doesn't have a very long resume because she's only 21, but she's a very brilliant candidate of our LLB. She's Pekarovic, but she's Portuguese, so don't be misled. And she will be, I guess, graduating and out in the market next year, hopefully. So we're going to proceed on her hands, so she will decide what we do, but the idea is that we will have 50 minutes, 55 minutes first part of the session, I guess by Cento, and then we will break shortly for 5-10 minutes, and then we will continue with Jeffrey Money. They didn't tell me, but I understand that if you have any short clarifying questions, feel free to do them. We are in an academic setting, and these are nice people. They will probably answer them. At the end, probably we will have time also for a Q&A if you have any questions. But that's all. Again, thanks for coming. Sabrina, the floor is yours.
Mm-hmm. Lazar, do you want to open anything, or should we just move to the discussion? Okay, so first we'll have Cento Veljanovsky. He's a managing partner at Case Associates. He's brilliant, as already was mentioned.
Thanks.
And he will be presenting a paper that he has recently written about the use of econometrics, and more specifically in the courtroom, and how this can be used as evidence. Thank you so much.
Thank you very much. I'm going to speak for about 20 minutes. And this is not a theoretical paper. This is what a sort of law in action, what actually happens and what position the expert witnesses put in a case. And I'm going to talk about 4 cases. These are the 4 decided cartel damage cases so far in the UK. And I think the best way to motivate the discussion is to quote the English and Welsh Court of Appeal, which said almost all damage claims rest upon a species of regression analysis, but virtually all such modelling suffers from a variety of reliability risks. So the Competition Appeal Tribunal, which is a specialist tribunal in the UK that hears these cases now, the High Court can also hear cases, generally is favourably disposed to economic evidence. Well, economic evidence is now almost central to any competition case, and it's favourably disposed to econometrics. But when we get to the decision, the econometrics starts to fall apart a bit as far as the judges are concerned. Now, just to put this in somewhat of a context of what's happening in the UK, after the Merrick's case, which was a case against MasterCard for charging excessive interchange fees, we have a new collective action, class action regime in the UK, and there was a lot of argy-bargy about how this regime, which was modeled on the Canadian model, would operate. But eventually the Supreme Court said, this is the way you do it, there's a low threshold. And then the number of cases coming before the CAT escalated dramatically. In financial year 21-22, there were 36 cases, and it shot up to 80 cases being heard by the CAT, and there's probably much more now. The cases, the ones I'm discussing are mainly party-to-party cases, but the cases coming towards in the CAT are complex, multi-party, such as interchange fees and trucks, and challenging and novel. There have been attempts to shoehorn even non-competition cases into the competition collective actions, such as water authorities polluting, argument being they're in a dominant position and they've breached their statutory obligations. The sums are mind-boggling. There's a case against Google on an ad tech claim of 13.6 billion English pounds. The Merrick's case brought on behalf of 47 million people was for 14 billion against MasterCard. There's a PlayStation case against Apple for 5 billion on behalf of 9 billion claimants, and there's a 7 billion Google search thing on behalf of extraordinary 65 million users. So I think someone did a calculation, and the number of collective actions against these companies equate to about 5 or 6 times the whole entire population of the UK. But these claims are obviously, let's put it bluntly, exaggerated because they're made by the claimant. And it has been quite controversial, the Merrick settlement, which was, as I mentioned, for 14 billion, but they settled for 200 million. And it looks like the litigation funders and lawyers are going to get the bulk of that money. So there's very little coming out. So going to the core of the discussion today, I'm looking at 4 cases brought in the High Court, 2 in the High Court, 2 in the Competition Appeal Tribunal. BritNed, which was a collusive bidding case, and most of these are follow-on actions from European Commission decisions. So although I'm talking about Britain, a lot of cases are brought in the UK courts because claimants like UK courts, a lot of them brought in the Amsterdam courts. Royal Mail, which was a follow-on action from the trucks cartel case. Royal Mail suing DAF. Granville and Chunghwa, which is from the the LCD panels, and Stellantis and Autoliv, which is of the occupant safety decisions of the Commission. And in all those cases, some form of econometric evidence was tendered by the claimant or the defendant. Now, if we look at these cases, what happened? And just to again put this in context, in the BritNed case, it was a claim over one project, and damages were claimed, and econometrics was used to try and work out the overcharge on that particular tender. And the court said, your econometrics is incorrect, and it was helpfully assisted by the defendant's econometrician, who pointed to all the flaws. But essentially, for those who, how many people here are economists or have familiarity with 1 or 2, 3, 4, 5, 6? Yeah, okay. The problem was that the sample they used was too small, in particular, and they tried to apply the average of the sample to a particular project, and the court said that that wasn't on. And what really did it in for him, or at least on the technical econometrics, was that the confidence interval was so huge that it could be almost zero damages or 36 million damages. So the judge was actually quite shocked by that wide range of the and the defendant's economists did a margin analysis and showed the margins were the same before and after the cartel. And the judge said that there's no overcharge because of that, but also because the lay witnesses, the factual witnesses that came to court said that they didn't, for the defendant, they said they didn't know the cartel was operating, and they priced the cartel based on the competitive conditions. And so there was no documentary evidence or factual evidence to say that the cartel that overpriced the particular tender. And that was somewhat supported by the gross margin analysis. That case is interesting because the judge went right off left field then. He said, no overcharge, but I'm going to give you damages because I've seen this one document. It says that the thickness of your cables, your copper cables, is much larger than the other your competitors. Therefore, I'm assuming that you've charged too much on the basis of these thicker cables. And then they said, because you were in a cartel, which never overcharged, you saved on common costs, the cost of actually bidding. So I'm going to give compensation for that. And the Court of Appeal said this is, the defendants only appealed the latter, common cost damages. And the Court of Appeal said this is complete nonsense that the judge is talking. Damages are compensatory, they're not cost-based. Because these common costs weren't paid by the claimant, there's no way that we're going to allow compensation for this. And had they appealed the baked-in inefficiencies of the thicker copper, that would have been struck down too. So the judge was trying to be imaginative and got skewed himself. He skewed the econometrician, then he skewed himself in the Court of Appeal. Royal Mail and BT against DAF truck companies. This is a trucks case. This was probably damaged the economic evidence or the giving of economic evidence more severely than any other case, because the economics clashed head on. It was a case in which the defendant's economist, who should have known better, but said there was zero overcharge, and the claimant's economist had said the overcharge was between 6.7 to 14.7%. And the courts basically said, because they went at loggerheads, they wouldn't agree on anything practically. There were differences that I'll come to in the econometric equations that they used. And the court, we have this concept in UK law now of the broad axe, where the judge can make a determination based on the evidence he's heard, but not necessarily on any particular piece of evidence. And so we had 0 versus 14. He said it was 5% overcharge. LCD panels, Grenfell versus LG. There, the econometrician, sorry, the claimant, who obviously was an economist from the Netherlands, did some crude trend analysis and got an overcharge, a very high overcharge. And it was the defendant who presented the econometric evidence that the court agreed with. So econometric was accepted, but not the the defendant's more simple trend analysis, and overcharge damages between 14 and 4% was awarded by the court. So there you have econometrics succeeding, but oddly enough, it was the defendant's econometrics to measure the claimant's loss. And then in Autoliv versus Stellantis, it's about seatbelts, steering wheels, and airbags. The econometrics was basically thrown out, and the court awarded 0%, well, no damages, even though the claimant's econometrician measured damages between 5 to 25%. So there we have the guts of these cases, and what went wrong? Well, let's start with the econometrics itself. It's not because the court was incompetent in addressing econometrics. In each case, the court did a detailed analysis and listened to the arguments very carefully and made statements about the econometrics. And certainly in the tribunal, the Competition Appeal Tribunal, we have a 3-member panel that hears these cases, and one of the members of the panel is an econometrician or an economist. So in the CAT ones, which rejected the overcharges in both those cases, one was a consulting economist, Derek Ridyard, well respected, and unfortunately in the Autoliv case, the member of the panel was a professor of finance, head of the finance department of Bayes Business School, and judging by his CV, someone who was a hotshot in econometric financial analysis. And he gave them a very hard judgment. He basically threw out the econometrics. And the reason, he said that the claimant's econometrician had worked back from what he wanted to get at. He had seatbelts, steering wheels, and airbags, I think. Get that right. Yep, airbags. And he took as the main period for the cartel what was in the commission decisions. He then had a pre-cartel period where he said, I looked at the documentary evidence and I believe that the cartel started beforehand. So in 2 of the regressions, he had a 2-period dummy variables, that means he just had 2 separate dummy variables for the pre-period and the main period, and he found that there were significant overcharges. But when he came to seatbelts, when he used the earlier period, he got a negative overcharge. That is, there was no overcharge in the early period or the main period. So he ditched the earlier period and just went for the main period because that gave an overcharge. So he was doctoring the results, basically. And the econometrician, we have the concurrent evidence hot tub, I think, basically pulled him apart. And the lawyers in White and Case, who I've worked with on a different case, said it didn't come across in the judgment, but and I confronted this case in the Amsterdam court the other week, is that he's a pretty arrogant individual. So he got his comeuppance. Was it the economists rather than the econometrics that was a problem? Well, it's certainly the case. We have expert witness rules that say you have to be independent, unbiased, and you have to, what now emerges is that you have to say why you've chosen a particular specification of regression, why you've approached it in this way. And the CAT is evolving its rules all the time to make it more clear about what data is being used. But it's quite clear, particularly in the Royal Mail case, that the economists were just at loggerheads. There was some issues in the econometrics about the global financial crisis, how to deal with that, how to deal with foreign exchange rates, et cetera, et cetera. But they just refused to engage in accepting that what the other expert done was a possibility and was within a legitimate way of doing it. And so the defendant's economist got particularly attacked. He got attacked for his econometrics, but that wasn't the real issue. He did a plausibility report wherein the economist, it's a practice now which I don't really think it's necessary, but they say why they believe there was an overcharge or not an overcharge, independent of econometrics, based on economic theory and factual evidence. And he did not reveal that he'd been working for DAF for the pre-commission decision, so he was advising on how to deal with the commission. So they got stuck into him about that, but not being candid. He lacked candor. He also was accused of lacking curiosity because he did not, apparently, on his evidence, ask DAF why it had engaged in a cartel and what was the benefits to it. And he did something that I think is impermissible. Is that he was used to present DAF's case as the expert witness. I know there's a couple of Australians here, but Mr. Justice Sackville had said that this is an illegitimate use in the Australian Federal Court of using experts as frontline soldiers in litigation. DAF was totally within its legal rights not to give evidence on this, but it used him, and that was obviously the legal strategy, to say, well, there was no way that this cartel could have overcharged. And so he got hoed into over doing that. They said his plausibility study was implausible. It was theoretical, hypothetical, and not based on any factual evidence, and contradicted the evidence that DAF had given to the European Commission in the Commission proceedings. So somewhat of the blame, and acting as an expert witness, and a lot of barristers and lawyers and even judges have never been expert witness or a witness of any kind. Under English law, the parties can retain their experts. So the experts are inherently partisan. They're paid by the parties, yet they have these overriding duties to the court to be independent and transparent. And so there is a tension between the experts, and some got it wrong. I would suggest that the DAF expert, apart from a lot of money resting on this particular case, because the judgment says that his consulting company were involved in 1,600 actions, damage actions. So this case was one of the first being heard, and it would set a precedent certainly for the UK claims. And also, he was chief economist at one stage for the European Commission and wrote an article saying how one's got to be careful in giving economic evidence. And he was drafted the European Commission guidance notes on the use of data and economic evidence before Commission proceedings, which is used by economists to present their guide them in presenting the case. So what do we make of this? I think that there's a whole swathe of conferences saying, how do we deal with experts? What are we going to do with the expert evidence? I think it's clear that the expectations of expert evidence and the way they're used are probably pitched a bit too high. It's first of all based on a fallacy, which has got nothing to do with economics, which runs through all expert witnesses, about whether there's a consensus within a discipline as to what the truth is, if you put it that way, and how to deal with particular fact situations. It must be strongly borne in mind that what the economist is, first of all, there's no other real method apart from admission by the defendant as to what the overcharge. It's a secret conspiracy. And not only is it a secret conspiracy, but in order to estimate damages, you're dealing with a hypothetical. What would have been the price in the absence of the impugned conduct of the defendant? And that's an unknowable. No one knows what that is. That can only be inferred from statistical or documentary evidence or some sort of accounting evidence. And so there's always going to be disputes about that. And obviously it's in a contentious situation. So it's wrong to say, well, econometrics is useless, because the courts have found it useful, because what the economists have been doing is marshalling a huge amount of data and presenting a lot of evidence. They narrow down the region. There's a lot of case management that goes into this, and more so coming on stream. And while the econometric evidence may be contradictory or conflicting or inconclusive, at least the courts have the benefit and the parties can express their position through the expert witness. So I think what is not acceptable is, and I think this is going to be washed out in the system, is the selective presentation of the results. And again, that's not only a problem in litigation, it's a problem in the academic world. I mean, there's been a number of research saying that, you know, to get promoted, you have to show positive regression analysis. And then someone who comes in and is, for example, there's publication bias. If I go in all the time with econometric analysis or economic analysis saying cartels have no effect on prices, I guarantee you I won't get published. But if I show that it has a positive effect on prices and there's an overcharge and the cartel has had long duration, I'm sure I'll get published in a lot of journals because I've shown something positive, I've not shown something negative. I think, having said that, we have to face the fact that there are inherent limitations of econometrics. And that has to do with the quality of the data. That has to do that you can legitimately come with different specifications that satisfy statistical robustness tests and which come to quite opposite results. And I think the courts now have come to appreciate that and know how to handle that. And the expert witness going in to the CAT at the moment will have to be very conscious of the fact that he will have to at least reveal a number of considerations that he probably wouldn't have revealed in say 10 years ago. He would have just gone in and said, this is my finding. But now he'll be challenged by not only the CAT, but the other side. Another, well, no, I won't go into any more technical details. I think you've got the message. And I should say, and I've hinted at that the courts themselves have not been consistent either. I've mentioned BritNet, where the judge gave a head of damages or two heads of damages that were never claimed by the claimant or even put forward by the defendant, and they even denied that it was. The same judge in the MasterCard, in the Sainsbury v. MasterCard case, put forward a counterfactual, which even the claimant said was not a realistic counterfactual of the issuer and acquirers negotiating interchange fees and the banks negotiating on a bilateral basis. They said that just won't happen. And the Court of Appeal said the CAT and the High Court, there were three judgments, on Visa and MasterCard, and all the judges came to different conclusions about what was the counterfactual. Could an economist even say anything about the counterfactual? One court said no, the other one said yes. And in the end, the Court of Appeal said that this is complete nonsense. You know, you got to use the counterfactual that the Commission used, and an economist can opine on industry counterfactuals because what's he there for? And then in the Autoliv case, it's generally been given as a guidance that the econometric evidence and the economic evidence should be consistent with the documentary and factual evidence. And in Autoliv, as I've said, the claimant's economist looked at the documentary evidence and said, oh, hey, you know, this cartel started beforehand. And the court said, he can't use that he can't interpret the documents. These are contested facts. It's for the court to determine what the facts of the case are. And there's an article by Sir Marcus Smith saying that the problem with economists is they pick up facts here and there and they, I wouldn't say make them up, but they don't give their evidence on the basis of adduced facts found by the judge. But of course, that's slightly impossible because as an expert, you're giving your report before the court has determined a lot of the facts that it's going to make. But in the Autoliv case, they said it was impermissible that he had come to the conclusion that the cartel had started beforehand, which for the econometricians here and the economists raises a big issue for econometrics, because when economists do econometric analysis, they take the infringement period as determined by the Competition Commission as the cartel period. The Commission itself has said a number of times that this is based on factual documents. It's based on not an offence by effect, but what's the term? Offence, object offence. So all they have to find is they met or exchanged information. And so if the econometrics is based on the infringement period is set out in the Commission decision, it could be wildly wrong, because if cartel prices existed before the date that the Commission said it started, and the econometrics is skewed by that, and it's normal now in the competition damage case to assert a run-on period to say that the cartel persisted for a number of years after, or a number of months after the end date of the infringement period. So there's an acceptance that the infringement period may not be the right period, but it does damage to econometrics. And I suppose the response of the econometrician or the economist expert is to say, well, that's where the claim sits. It's a follow-on action on the infringement period set out in the Commission decision. The final comment, I know running a bit over the 20 minutes, is does it make any difference that we've got a specialist tribunal or a judge, single judge, making a decision? Well, two of the cases were brought in the High Court with a single judge, Britnet and Grenville, the LCD one. And two of the cases were brought in the CAT, the Royal Mail and Autoliv. And it's hard to tell the difference between the two cases. The single judge came to just as good an analysis or as bad analysis as the tribunal. And so it's a sample of 4, which for lawyers is dramatic, isn't it? That's a big sample. You just need one. Well, we'll wait and see because the other cases coming through the CAT are collective action cases, which are huge mega cases, and we'll see. But being involved in some of these cases, I think I think that's a different matter. So, and I've got a list of things what the experts should do, drawing out of these cases, which I won't bore you with, but it's quite clear that you have to be quite open as an expert about the regression analysis, why you rejected some regressions, you put forward these regressions, what the problems are. Omitted variable bias seems to be a big issue that the CAT's seized on and the courts have seized on. And you're required to declare a statement of truth or express a statement of truth at the end of your witness statement to say you understand the expert witness rules and you've complied with them. And clearly some economists have not complied with them. But economics is central, I said, useful. Econometrics has limitations, and the lawyers and the opposing economists will no doubt pick them apart.
Thank you so much.
I'll tell you what to do. I'll tell you what to do.
Thank you. That's why we've got you here.
Yeah, exactly. I was going to say at the start of my remarks commenting on your paper, essentially exactly what you just said now, which is that one has to be careful not to look at the excuse me, at the imperfections of econometric analysis and assume that it means that it's not only that it's not useful, but that it's not central. It is central. It has been for a long time. It does seem that it's generally useful, and it's important to understand the institutional context in which it's being put to use. And often that means adjusting the rules around it to try to reflect, where those imperfections lie. I was going to talk a little bit about that history, but maybe we'll save that for the next session. And just let's just say we all agree that economics and econometrics are central now, whatever they were like before. And it is important, I think, to note that before there was, I mean, Chento's talking about a pretty narrow area of the determination of cartel damages, but more broadly, before economics was central to antitrust, it was a pretty troubled sort of discipline with very little consistency. And whatever you think about the way its general focus has changed since, the 19th century to today, I think the most important change is that economics has imposed some discipline on the discipline. It's imposed some discipline on judges, or at its best, it does that. It's interesting to look at situations like this that actually kind of exacerbate the lack of discipline, that where you have the competing experts providing incommensurable data and analysis, and you're essentially asking a judge to either pick between them or pick some sort of average between them, which is actually kind of interesting. In a way, it's that whole process that, and as you pointed out, the expectation that it's going to do better actually introduces a new measure of uncertainty and lack of discipline that is, probably problematic. But you always have to remember what the counterfactual is. What's the alternative? The alternative is almost certainly worse. It's also interesting that one of the points that Cento made was that that there are circumstances, I can't remember, I wrote it down, but now I'll lose my place if I go look for it. But there are these circumstances where the effort to provide more certainty, more accuracy, also brings in more complexity, almost by necessity, and therefore the more challenging, presumably, it becomes for judges to actually evaluate what's in front of them. It's sort of a classic error cost issue. There's a point at which increasing our knowledge may, in the abstract, increase our ability to get it right, but it may also increase the administrative burden of actually getting it right so much that the net out effect is negative. And that's why I mentioned that it's so important. That's why the institutional setting is so important. That's why we have things like burdens of proof, and we have various standards of evidence, and of course standards for experts themselves. And not that they're in any way perfect, and they're probably worse than the econometrics, but presumably they are the kind of thing that can and will evolve along with the use of econometric evidence, so that in an ideal world, I'm not so naive as to think we'll ever be there, but if people are doing their jobs correctly, maybe we can make adjustments to the various standards that will mitigate some of the problems that you mentioned. I also want to point to, for everyone's benefit, there is an empirical study with more than 4 data points looking at in the US and asking essentially the question whether judges with more economics training or some sort of more economics expertise do a better job than pure generalist judges. I mean, it's actually aimed literally, I think the study was done at a time when there was some discussion of having specialized tribunals in the US as well. And it does seem, it's not actually super strong evidence, but it does seem that judges that have some economic training seem to do better than ones who don't. And by better, and this is where it's at least fuzzy, by better, it means less likely to be both appealed and overturned on appeal. And that, of course, implies a lot about the appeal and who's doing the appealing. So, like I said, it's a little bit weak, but at least it is some evidence. The other thing, a couple of things that, to think a little bit more broadly than the cartel damages case, I just want to mention that you're reading your paper reminded me of the Google search case, actually, which is going on right now in the US. And in particular, 2 aspects of that case are really interesting and relevant to this question. The first is the theory of harm in that case sorry, the Google search case, you all probably know what Google search is, right? But the case is based on the fact that Google entered into agreements with Apple and Mozilla and other what are they called? Search access points to be the default search provider. So, you know, when you open your phone, Google is already installed. It's not, however, actual exclusion, because you can always switch. You can always install another search provider. You can always switch away from the default. But the theory of the case was that, nevertheless, being the default provider is so psychologically is such a psychological thumb on the scale that you actually can, in fact, sufficiently effectively exclude competitors simply by having being installed as the default rather than being, you know, installed as the only search provider. And the basis for that was behavioral economics and behavioral psychology. And you know, obviously I didn't see all of the trial materials, but there's nothing in the opinion that I noticed that suggests any quantification of this effect. It accepts, and I mean, obviously, sorry, the effect is it's a kind of lock-in effect, right? It's like there's an increased switching cost, and that increased switching cost is significant enough to reduce scale, to reduce a competitor's ability to obtain sufficient scale. And the problem is, like, there are a lot of words in that, like sufficient, and you know, the standard requires a certain amount of exclusion, and in part because the counterfactual is always hard to identify. We have no idea, actually. At least there was nothing in the opinion that suggested exactly how strong a default is. It said which direction it cuts. It's clear that having a default makes it a little bit harder for people to switch, but how much and how many people and how much scale is required, and is there actually a correlation between the two? You know, there were many and very talented economic experts on both sides of this case, and I'm pretty sure that no one ever actually answered that question. And that gets to the second. So the first point is to say the problems with the kind of regression analyses that Cento is talking about are definitely magnified when we're talking about economic theory and when we're in settings where there really isn't empirical data, or at least there isn't probative empirical data. The second point is that it goes back to my where I started with the interest. What I think is interesting about the relationship between the institutional setting, the effort to reduce error costs, and the way economics works, and that is that the legal standard in the Google search case is one that doesn't require them to show to actually prove what the but-for world would look like. They can infer causation. They can infer that Google's conduct caused the harm. They don't actually have to show that in the but-for world, Bing, let's say, would have achieved sufficient scale to be a viable competitor against Google. Excuse me, and nor do they have to show that it was in fact these default agreements that that precluded that. And that's because of the Microsoft case, which has this, as the court itself describes it, edentialist standard, which for those who are not up on their Latin, at least I think it's Latin or Greek, I don't know. You'd think I would know, I studied Latin in college, but edentialist means toothless. But for reasons that make a lot of sense in this particular setting, where the but-for world will never be known, and where, at least in the Microsoft case, I question whether this is true in Google, but in the Microsoft case, the sort of the mechanism by which the harm was supposed to happen was totally speculative. It was a nascent competitor. They had this idea about what it could become in the future. And not only would there never be any evidence, but even the theory, it was inherently speculative. And so in that setting, the court said, well, you don't, you get a relaxed burden of proof, because otherwise you simply cannot, you'll never win those cases. And we believe you should sometimes win these cases. And that's essentially I've already gone into too much detail, but the point is that it's a very relaxed standard that's being applied in this case. And I'll sort of end with a conundrum that creates, because obviously even in these hardcore cartel cases where we actually have a fair amount of evidence, and where we have a very probably not in all of these cases, but in general, we have a pretty clear sort of theory of harm. Even there, I suspect that, or even there, Gento points out the the difficulty in proving or establishing what the but-for world looks like is always there. And so it does, of course, make sense to adapt procedural rules to take account of that. But I guess the question I leave us with is, maybe that's what we should be talking about. Maybe we don't have that right. There are obviously differences in what should be required in a remedial phase than in a liability phase. That's even true in the Microsoft case and the Google case. Maybe it's just because I'm a lawyer. I want to talk about what legal rules we should adapt to deal with this situation. But I think it seems inherently unovercomable in many settings.
I have a brief question for both of you. So I found it especially interesting that both of you mentioned that certain complex economic evidence is often dismissed in courts in both the US and the UK. And I was just wondering, in both of your extensive experience in economics and as an expert witness and in academia, what sort of economic evidence are judges usually open to and what is still being rejected? Perhaps more behavioral economics is accepted while econometrics is often too complex, or what's your opinion, and maybe the US perspective and a UK perspective?
Well, I don't want to give the impression that economic evidence is dismissed by the courts. I'm just focusing on these 4 cases where econometrics was used. I can quote a number of cases where the judges said the economist evidence was useful, and you've got to accept that there's a difference between the use of econometrics and the usefulness of an economist in the case, because there was an economist in each of these cases on the other side who technically can claim victory because they did the best for their client and won the case in a sense by knocking down the other person. And I certainly don't want to give the impression that the Competition Appeal Tribunal is anti-economist or anti-econometrics. It just happens that in the cases that have now been decided, that apart from the Grenville case, econometrics has come out pretty poorly. I think the central question is, let's forget about the lack of independence or bias of the economists giving the econometrics, is that there is an inherent limitation to the econometric evidence. And no one's saying that the econometric evidence is the be-all and end-all of any case, even for the economist. It's part of the mix of evidence that goes before the court and they decide on. And sometimes one gets the impression that they are critical of the evidence, but they would have come to a different judgment had they not seen that evidence in the first place. It's been very useful for them to see it.
Even if it's a by-object case?
Yeah. And also in one trucks case I've been involved in, the economists were a bit at loggerheads and they went on for ages. But I've got to say that the accountants were even worse. They didn't agree on anything. And I think another difficulty is the conciseness of the evidence being given to the court. In the Royal Mail BT case, there were 27 expert reports given to the court. And what is tending to happen at the moment, and the court has already made, or in that case, saying that there must be more restraint on the part, is that the economist presents a report, there's a report by the other side, each says the other one's wrong, produces another report, and then they they're supposed to produce a joint statement which highlights what they agree on, disagree on, and why they disagree. And that thing then turns into a 120-page tabular report saying, you know, I disagree with this and this is why. So they're rehashing the thing. And then one of the economists will say, I want to give a supplementary because some of the issues that have been raised here are not the ones that I directly discussed, and I want to. And so my fellow economists, sometimes I ring them up and I say, what the hell are you doing? You know, this report is supposed to be just a guide to the judge, and you're turning it into. And so he's gone running to his lawyer, and the lawyer sent a nasty letter to my side, the lawyer saying, you know, that this is outrageous, that he's got to be able to explain. And then it goes to a hearing before the CAT, and the CAT says, no, you're not going to do it, but you can add a few things to the supplement, to the joint statement. And it goes on. And it's that procedural difficulty that is driving up the cost, because I didn't mention, but in, say, Royal Mail, the damages ex interest, it was 20 million. The experts' cost and the lawyers' cost was 20 million. So, okay, that case, it was somewhat of a precedent, but the CAT and the judges are starting to comment on the expense of some of these cases.
I think there are two things I want to comment on. One is the kind of irony, I guess, of the recognition that the simpler it is, the more you can rely on documentary evidence or behavioral economics or other kind of fun theories, you know, the less reliable the outcomes are. Maybe it may be intelligible by the judges, but I think it's fair to say that the probative value of both of those, let's just, you know, there are other things too, are very limited. You know, behavioral economics is really great at providing intuitions and helping understand some human behavior. It has so many conflicting attributes to it, though, that it offers almost no, I mean, that maybe, in fact, you know, its most robust conclusions are constantly being undermined by subsequent research. I don't think any of them are really robust, as informative as they are in terms of thinking about, you know, sort of tendencies and the like. So but it is really intelligible by judges, but that, you know, that may not be enough. And the problems with documentary evidence is legion. You know, the documentary evidence is often so much more pejorative than probative, and less so obviously when you're calculating damages, but when you're determining liability, there's always an inclination to, you know, fit everything into a story. And a story often always includes, you know, motivation. And the law may not care that much about motivation. It may care much more about effects. And often the documentary evidence that seems to be touted the most strongly really goes to motivation. It doesn't really go to determining what the effects are. There's plenty of documentary evidence that does, of course. I think Cento talked about some of it. I mean, obviously documents are extremely important in measuring effects, but again, they can be extremely pejorative in a way that, of course, is very easy to understand. Everyone can understand a story about, you know, when you the CEO of some company who said, we're going to, you know, drive them into the ground and make sure they can't get any business, and just assume, and it's an exclusion case, and so you just assume, well, they tried, they wanted to exclude them, they must have. That's what the case is about. And of course, that's not really true. The other thing that is interesting to me that is true in the Google search case and is implicitly true in all of these cartel cases, and I wonder how much of this can be explained by this, and how inherently problematic it is to have I'm giving you all this build up and you're like, what are you talking about? I'm about to tell you. This is the separation of the liability and remedy phase of the trials. It's inherently it happens in the cartel cases, obviously. It's happening more and more in U.S. Cases in you know, sort of complex litigation. The plaintiffs, and it's always the plaintiffs who want it, say, let's determine liability first, and then we'll look at what the appropriate remedy is. And the difficulty with that, of course, is that if you you know, if you can't, or the inherent problem, I guess, is if you can't, you know, if you can't design an appropriate remedy, you may not have a basis for liability in the first place. Or even if you have a basis for liability, if there's no remedy that's not worse than the disease, maybe your theory of harm has some problem in it. Actually assessing the remedies while you're assessing the liability phase and the theory of harm is often very important. I think one of the examples you gave showed that even in the cartel case, or there was an effort, I guess, in this case to try to. It sounded like in this case it wasn't viable, but imagine a scenario where the appropriate approach for the econometrician was one that looked very different than the term of the agreement or whatever it was that the commission had previously decided. But what if the economists were right as a practical and factual matter? It actually should change, perhaps, whether there should be liability in the first place, but certainly the theory of liability. And so I think that may be an area to think about where we're made in some cases unnecessarily making things worse by having that separation. On the other hand, it may be impossible to do otherwise in some cases.
Yeah. But in the cases that, even in these large sample of 4 cases,
Yeah, right.
I've got a sympathy with the judges and some of their logic, because some of the, not necessarily the econometrics, they will say, you're saying that the overcharge is 20-30%, and in the one case 70%, and you as the claimant didn't recognize that an overcharge of that magnitude. You never made any comment during the whole period. Is this realistic that someone would? You're a sophisticated, you make Fiat and Chrysler cars, and someone's selling you an airbag that's jacked up the price by 20 or 30%.
Is this the plausibility analysis thing?
Well, it's not even,
could be.
well, it is plausibility, but it's a judge making a comment saying, there's problems with your analysis, but one of the bigger problems is you're suggesting an overcharge, which any sane commercial operator would have recognized that you're being ripped off. So that's one case where the documentary or just the common sense thing has trumped the technical evidence in that case. And that comment's been made in 2 cases, and I've seen econometric studies that have suggested that a very high overcharge, which just doesn't seem plausible. I mean, the econometrics is there, but it just doesn't seem practically plausible that someone will be overcharging that amount of money and getting away with it when the purchaser or the seller is so sophisticated and has been operating in the industry for decades.
Should we have a 5-minute break, and then after the break we'll do a Q&A from the audience? Thank you so much.
Thanks.
Can we take these off? Oh, no, probably not.
Questions?
Go.
Very interesting program. So my name is Enrique. I work with the Spanish Competition Authority. We published 2 years ago a guide on quantification of harm in antitrust cases and in claims damages. This was mainly intended to help judges in interpreting all these expert reports with so much econometrics. We even included a checklist to be followed by the judge when reading the expert report. So asking questions about very difficult questions, maybe for a lawyer, like is there a problem of heteroscedasticity, for instance, or names that may not be so understandable for legal experts. And my question is, so I found very interesting the UK experience. So maybe, Cento, you can explain to what extent are detailed the assessment by the judges, to what extent are they detailed and technical? Do they go into all these econometrician questions, because many times the problem is really in the details. So the devil is really in the details, and I find it really difficult to have a discussion with someone that is not expert. So all these assessments do they go point by point? Do they follow a systematic approach? Because I guess it's not a peer report like in academics. You need to do really something that is maybe intermediate. So this is my first question. And is there any kind of template like the one we have proposed here in Spain by the CNMC? By the way, I think in Spain, the assessments are not really going to the details. They sometimes make reference to problems like sample bias or omitted variable problems, but they don't really go into the details or, yeah. So that's my question
Yeah.
to.
Okay. I think the general answer to the question is they go into the detail. And I think the evolving practice now is if you start off a case, let's not talk about the collective actions, but you're asked to issue a methodology statement. What are you going to do? What data do you need? And there's a case management conference, and they look at those things, and then they issue some sort of protocol. And the Competition Appeal Tribunal, I'm not an expert in their procedural aspects. I mean, I just get the blunt end of it when they say, you know, we want a methodology statement from you in 2 weeks' time. And then there's been a recent innovation, which I don't think is going to be repeated, that instead of having the lawyers ask for the disclosure, the economists will identify the issues and ask for the data, and that seems to have caused high costs and more complications than it's worth, I think, at the end of the day. But as far as the judgments go, the ones I've referred to, if you read those, you'll see that they go into some detail about what the problems were. And obviously there's been multiple reports given to the CAT. So when they say you've got omitted variable bias or endogeneity problems, or that's obviously a reaction to one of the opposing experts' reports. And then you have the addition of the economists sitting in the court, in the Competition Appeal Tribunal. And we have the hot tub, which is concurrent evidence, where the experts sit together. And the CAT is actually more inquisitorial than a common law court. And so you'll have one of the members of the panel in the Autoliv case, effectively a professor of econometrics, asking questions of the expert, you know, why did you do this? What happened here? If you read the judgment, they say, you know, if you take out the two periods and just have a dummy variable for the whole period, you get entirely different results. This is unacceptable. It's not good econometrics. So the answer, that's a long-winded way of saying that today they're getting into a lot of detail about the econometrics. You're just not going to get away with sort of arm waving and stuff like that. And they will make a judgment sometimes about which approach is better. But if you've got two opposing econometric analysis that satisfy, you know, the statistical standards, the court has to make a judgment at the end of the day.
A judgment that they're not really qualified to make.
Well, if there's got an econometrician on the...
If you don't mind, we'll move to the next questions so that we have time to answer all of them. Does anyone else have a question? Francisco.
I have a question for Chento that has to do, you mentioned that one of the problems was that the experts, or at least in trucks, they were being used as the advanced defense by the defendants.
Yeah.
And so, and you also, I think, talk about the fact that there was some sort of teamwork with the lawyers on what was the strategy, how were they gonna defend the case or whatever. But I find that that's probably the case, but I think why do the experts allow their clients to force them to do that? Because they're ruining their reputation, and well, obviously you're going to tell me it depends on the price you're charging, but isn't there a problem of you're right when you say that the disagreement between economists is nothing special, so there's something similar in other professions, but isn't there an ethical problem which is more acute in economic experts than in other professions?
Well, there's a lot of questions in that, but yeah. Yeah, it's a bit invidious to pick one expert and what he did in that particular trial and sort of generalize from that. But that particular expert, I think it was a general feeling within the consulting economist profession that, wow, this guy's really mucked this up. You know, he's gone out on a limb and he's sort of become an advocate for his client. And he got caught out by the court. And whether he's going to appear in another case in the UK is a moot question. So the market works, if you can borrow an expression. You know, his reputational risk is now high. So that's been the outcome. And I think generally, I know one very well-qualified Spanish economist who will not get himself in that position. We're working with him, he's on one of the claimants, and he's very conscious of the Royal Mail decision, and there's no way he's going to put himself in that position that expert did in that case. And every time someone says something, he says, well, we're not going to do the Royal Mail thing. So, you know, as the system evolves, people will recognize that you're not going to get anywhere. And of course, you know, the client, it's my interpretation, but it was quite clear there was a legal strategy of the DEF not giving any evidence and using him to give the evidence that this cartel had no effect. And he was lampooned by the court, the tribunal, for doing that. And it affected his credibility in the whole case. They said they took seriously his econometrics, and they went through the three differences between his econometrics and the other guys to come to different conclusions. But in the back of the mind, his credibility was shot on that because he didn't reveal that he'd worked for DAF, you know, since before the commission decision. He was an industry advisor rather than an expert. There's no problem with that, but he didn't come clean on that, you know. And quite frankly, if it was a young economist who did it, you could have made an exception. But this guy was the chief economist in the European Commission, had written an article about economic consulting and the need for not taking extreme positions, and you know, wrote the Commission's draft on how to give sound economic evidence in proceedings. So there was no excuse really for what happened there. But
if I may interject, I have an add-on question to this that's not as related to bias, but perhaps towards experts often being treated differently in economics. So a lot of experts in economics are treated with suspicion in antitrust cases. However, in other fields like medicine or technology, differing expert views are quite normalized. Why do you think this is the case?
Well, I think we've had some travesties of justice from social workers giving evidence in cases, psychiatrists and psychologists giving evidence. I think the consequences of bad evidence in those cases is much more severe than, you know, whether the claimant's going to get 10 million or 20 million in an antitrust case. And I don't think I know there's all these jokes, you know, you lay every economist in the world end to end and you never come to a conclusion and all that. They always disagree, but there's no more disagreement, I think, than a lot of other professional experts. And I think there are confines in which within which the economist operates, you know, a theory of harm. He's got professional standards. Now, he may rig the results on the econometrics, because there's an intense pressure from the client. I mean, if you're hired by a client and halfway through the case you decide there's no case to answer in terms of you're going to veer towards interpretations of facts that are more supportive of your client. They call it unconscious bias, but and that's been noted by the courts for centuries, that the expert will often come out to a conclusion that, and there's a selection process going on too, because you go for a beauty parade and you say, do you agree with our case? And if you say no, then you don't get hired. But if you say, I think there's merit in it,
Interesting.
you get hired, and then your professional reputation's on the line. And sometimes the court is unfair with the economists, but it doesn't matter,
So independence.
And certainly within the common law system, I write a report and I get a bit carried away. And then I think, God, I'm going to be in front of a barrister and he's going to look at this. And then he's got an economist in there. And he's going to rip this to pieces. So I start crossing out things that say maybe rather than it's, clearly. So.
Should we move on to the next question and then perhaps Jeff's presentation so that we have time to cover everything? Yes. Thank you.
First and foremost, I would like to thank you for the invaluable insights you provided to us. If I may have 2 questions, is there time for 2?
Start with one and we'll
Okay.
see.
So since you have mentioned an econometrics can fall short in providing causality or intent, do you believe that systemic firm audits could help fill in the gaps where conduct is not observable, but market outcome raises concern, especially in terms of cartels?
I mean, I guess I certainly think that economic theory and is helpful in filling in gaps where you have to make guesses at causation, and I mentioned intent, but intent really shouldn't matter. But causation, right? I mean, that's really what you have to have a plausible economic theory that connects the 2 things together if you're not going to actually prove it by documents or econometric evidence or something. Clearly, economics is helpful in that. It's just that the places where there's disagreement between the experts in the cases that Cento was talking about, I assume is predominantly in the areas where they're making inferences. And I mean, not exclusively, but at some level, the differences they're definitely going to have differences because they're going to make different sets of inferences. And in a case like Microsoft or Google search, where you have a sort of economic theory that is filling in the gaps, there'll be very wide differences. One side will say, yeah, this is totally plausible, and the other side will say, of course, that's ridiculous, and and neither is falsifiable, really. But I do think the having an economic theory and having that sort of discussion will get us closer than. I'm not even sure what the alternative is, just making a random guess. I don't know. Or looking at intent. Intent will rarely get us the right answer, I believe. Yeah.
Certainly on cartel damages, it's a technical question, really. How much was the damages? And it's a quantification issue. And
relative to the but-for world. And that's
and you can, we've worked with accountants on this, using econometrics, looking at profit and loss accounts and the gross margins. So the economists, in these cases, have used different methods. They just haven't seized on the econometrics. Here, I'm just saying that the econometrics, given our sample of 4, it's a 75% failure rate. And it's basically what we've got now. As we move on to these more complicated digital cases, the theory of harm is everything, because is self-preferencing an abuse or not? People differ, and as I say, the critics are out, have not decided which way, and so it's up to the courts to sort of carve a path through these different theories, and the economists working independently or giving evidence in these cases to come to some conclusion. But no lawyer, certainly in the competition lawyer in the UK, would go to court without an economist, economic expert
If we could save your second question to the end, if we have time, after Jeff's presentation. Thank you
Thank
so
you.
much.
Figure out where my presentation is.
Mhm.
Um,
So Jeff is the founder and president of the International Center for Law and Economics. He has extensive knowledge in economics, and he'll be presenting more generally the use of economics and law. And I hope it's insightful. I'm sure it will be insightful.
I hope it is too. I have more prepared than we have time for, so I'm gonna be selective as I look through my notes. And I already said that, so I'm gonna skip that. So I think what I want to talk about is bigger trends, I suppose, and you know, it's exactly what you would expect with an economist and a lawyer sitting next to each other, that the economist would actually talk about the details and the lawyer would, you know, tell some story about broad, completely unfalsifiable political trends, but that's what I'm going to do. And but I think that there's a tie-in to what we've been talking about. And so first I'm going to point to the overall trend, and you could quibble with this, I think, and it might be interesting to talk about where it falls flat. But, you know, despite what I said earlier, and despite what everyone kind of knows, that, you know, before the 1970s, economics didn't really play a very significant part in antitrust enforcement. I have to put a caveat next to that and say, it is remarkable, however, how judges like Oliver Wendell Holmes or Learned Hand, and these judges who are not really economically trained, would actually make what turned out to be very savvy and sophisticated economic analyses without knowing that's what they were doing. So even then, I wouldn't say economics had no part, but clearly not the same role that it has had since the 70s. And then I, you know, I think it's fair to say that it's being challenged more today, that since the neo-Brandeisians sort of came to power, since we've seen moves in Europe from, you know, toward ex-ante regulation. Again, all of these things have exceptions. I'll just have a blanket caveat like Cento's. I'm talking about more than 4 out of, you know, however many hundreds of cases, but there are exceptions, that's fine. This is a general overall trend, I think. That it's sort of the role of economics in antitrust enforcement, sort of writ large, is definitely kind of under threat, and it's under threat from the left and from the right. It's under threat for different reasons for different people, and I think it's worth sort of, I guess, taking stock of that. I think rarely are the challenges that we're seeing today to economics in antitrust based on the kind of technical problems that Cento has been talking about, although not infrequently people will use that kind of problem to as a sort of smokescreen to justify a broader position that they want to take. In other words, we shouldn't be talking like this. We shouldn't be saying out loud that we have these kinds of problems, because that'll be used against the general approach to economics. So we have to delete the recording of this and don't talk about it again, Cento.
Too late.
I know. I'm kidding. So I think what we're really seeing is a re-exertion of, and people hate it. I'm going to use this language because I think you all know what I mean, but of politicization. And as soon as you say that, someone will always say, I mean, the use of economics is inherently political. You know, it's just it's a different politics than the politics that seemed to emerge when economics was more significant. But I don't think it's quite that simple. I think that what we're seeing is what we saw in the sort of pre-economic phase of antitrust enforcement was in fact very explicit, very overt, non-economic goals that were being sort of imbued, antitrust was being imbued with, sometimes by the very people who drafted those laws. That's certainly fair, certainly not by everyone who drafted those laws. But then of course by judges, being influenced by enforcers in interpreting it subsequently. So, there was a focus, rarely was there a focus on consumer welfare. In fact, for some judges, among them most prominently perhaps, and one of the most important antitrust judges in history is Brandeis himself. Brandeis himself hated consumers, and understanding that the consumer welfare standard is broader than consumers, but consumers are very much a part of it. Brandeis was not a fan of consumers. He was much more interested in preserving a sort of structure of markets that he thought was conducive to certainly things like democracy and justice, but even something a little bit more inchoate and almost aesthetic than that. And there were others who thought, preservation of small business was important. Others who thought big was inherently bad, concentration was bad. That antitrust should be used to regulate labor markets. Anyway, until economics came along, that's often how the early decades of U.S. antitrust has been described. And I think what we're seeing today is the recognition that, to some degree, the more economics we have in informing our antitrust decision-making, the harder it is to imbue it with idiosyncratic political preferences. It's very clear that, following the Chicago School Revolution, that certainly didn't go away, but it was dramatically diminished in the way antitrust cases were decided in the US. And I think there are people out there who regret that, who would rather use antitrust to affect certain political ends because it happens to be convenient to do so. And this is not, a novel theory. I think it's fairly straightforward. Economics gets in the way of that, so economics becomes the enemy. What's particularly interesting, I guess, about the movements today that are trying to repoliticize antitrust is that they come from both the far left and the far right and seem to have a lot in common with each other. Again, as I'm not the first to point this out, but we went through a few years of the neo-Brandesians, and it was very clear what they were interested in. And then we have the new administration come in, and the announcement of, I said in the beginning, right, this is all about the U.S., didn't I? So, this is all about the U.S. I'll talk about Europe in a minute, but right now I'm talking about the U.S. So we have a new administration come in, and the announcement of something called America First antitrust, or MAGA antitrust. And then when they explain all of the tenets of this, leaving aside some window dressing that is supposed to make it palatable for conservatives, it's very similar to what the neo-Brandesians wanted. That itself might be interesting, but I think what's most important here is that both sides seem very willing, and in fact, I think it's very important to remove the constraints on discretion, the ability to exercise both enforcement and adjudicatory discretion, because that discretion would enable them to achieve other objectives that they'd like to achieve. In the neo-Brandesian case, I have some quotes. The neo-Brandesians view antitrust as public law in service of the public interest. Very concerned with the structure of markets, very concerned with economic inequality, worker protection, viability of small businesses. The America First version of that is very concerned with so-called pocketbook issues. I don't know exactly what that means, but I think it means how much money people have to pay for consuming stuff. They are also concerned with bigness. They're very concerned with the structure of markets, because there's a sense that there's a certain kind of a structure of the market that has a moral valence to it. That there's something good and true about the Jeffersonian agrarian economy, and a sense that we should return to that all of our laws should be pushing in that direction. And antitrust law happens to be very a very powerful one. We need to use it to make the economy look like, I don't know, a bunch of subsistence farmers or something like that. They wouldn't use those words, but that's sort of where they're going. In fact, what's under the America First sort of approach, they explicitly say that antitrust is an exercise in law and policy and morality, not in economics. And among other things, one of their strongest adherents, who also happens to be a commissioner on the Federal Trade Commission, has suggested that we should have congressional legislation that restricts the role of economics in antitrust. In any case, there are some overlaps in what they're looking for. There are also some clear divergences in sort of what they're looking for. And I'm sure there are plenty of others who have their own political agendas that they're trying to imbue in antitrust as well. They just don't happen to have movements that have gotten their adherents placed on the Federal Trade Commission, so we don't talk about them as much. But everyone has those kind of preferences, and economics tends to stand in the way, despite the despite the ways economics fall short of some very heightened expectations for it, despite the fact that it's always imperfect, and that of course any particular use of it in a given institutional setting may be imperfect. There's no question that it imposes constraints, and that there are people out there who would rather not have constraints imposed on them. There's when you're seeking to replace something like the consumer welfare standard with concepts like fairness or the public interest, as some have very explicitly advocated, you're really opening the door to arbitrary and unpredictable enforcement. And if you think that a judge, picking between two damages calculations and picking a number that no one thinks actually represents what actually happened, but if you think that's arbitrary, you ain't seen nothing yet. But I mean, although that is in a sense arbitrary. Although I actually kind of like that. We should talk about that again. I kind of thought that was a good idea. I think I think one of the interesting facets of this is that the bringing in economics from the sort of Chicago Harvard Revolution in the 70s is kind of to blame for the repoliticization of antitrust today, in the sense that it did in fact constrict the ability of people to exercise their political preferences, and they resent that. And it happened to come at the same time as part of this so-called neoliberal, what is it called? The neoliberal agenda or something like that, that also constricted other regulatory interventions, and a general sense that certain types of regulation were very difficult to get passed through the democratic process. And even if they were passed through the democratic process, courts especially, but others, legislatures as well, had been putting constraints on what exactly you could do under even ambiguous legislation. And antitrust is this really malleable, really vague sort of set of standards that can be adapted to a lot of political ends, which is exactly why it was problematic before, which is exactly why economics is useful in constraining it, and which is exactly why economics is a primary target of those who seem to be interested in, as I said, in sort of repoliticizing antitrust. It's particularly, I guess, interesting to me that it's true not just from the left but from the right, where you have the current Assistant Attorney General and the current chairman of the Federal Trade Commission and one of the current commissioners, who are self-avowed conservatives, and conservatism has traditionally espoused generally a more economic approach to regulation, has certainly espoused things like free trade, has been informed by the sort of Hayekian knowledge limitations and the idea that there are limits to how effectively we can intervene in markets. And now you have the self-avowed conservatives who are disavowing that and explicitly sort of condemning economics in antitrust. I want to get, and let me just suggest that this isn't just theoretical. We do have the courts as a kind of bulwark in the US. In any common law system, you tend to have, you have to get past a court that has established precedent over many years, and you can't just change it overnight unless you have compliant judges. And given that the executive branch is the one that appoints the judges, eventually you will have compliant judges. So, but we have something of a bulwark against sort of wholesale change in the way antitrust is done. But that doesn't mean that nothing is changing. So the sort of Exhibit A is the 2023 merger guidelines in the US that have you know, what facially appear to be kind of subtle shifts, but I think are very clearly a diminishment of the role of economics in merger analysis and enforcement. A shift toward the reliance on structural presumptions, and importantly to me, a shift toward standards of proof that are much more reliant on things like documentary evidence than econometric evidence, that imbue documentary evidence with a kind of degree of probative value that they may not have, but they contribute to a good story. And I mean, I'm exaggerating a little bit, but under the new merger guidelines, that's perhaps sufficient to establish a violation of the Clayton Act. And in fact, we have at least one court since the 2023 merger guidelines were enacted. They don't have the force of law. They're not, you know, the fact that the merger guidelines move, you know, sort of suggest that the enforcement agencies will diminish the role of economics doesn't mean that courts have to. It doesn't mean the law has changed. Nevertheless, courts tend to look to the merger guidelines, and so there's one. There have been a couple of merger reviews since the 2023 merger guidelines, one of which very clearly suggested that what mattered most for the determination of actually in that case, I think it was the market definition determination, but it happens in effects analysis as well, was you know, the qualitative evidence, not the quantitative econometric evidence that would normally be used to demonstrate that. Now, it happened in that case that the judge suggested that there was in fact econometric data and that it went the same direction as the data that he relied on, or the, you know, the qualitative evidence that he relied on. But it's telling that that was the approach that was considered acceptable, and that of course that establishes precedent going forward. The state of California is considering revising its antitrust laws, and just published something, the sort of director of that process, which will ultimately be make recommendations to the California legislature. And in this process, the California legislature generally accepts these recommendations through this law revision commission. The person who's directing that process just wrote something saying, there's a convincing body of literature supporting the update of antitrust laws to counter the decades of federal jurisprudence informed by certain Chicago school precepts, which time and scholarship have revealed to be unfounded. You'll be shocked to hear that there are no citations to the literature that supposedly demonstrates that it's all unfounded. And of course, there's been an evolution in economics. There's a constant evolution in economics, and not everything that the Chicago School said in 1975 or whatever is exactly correct today. But for the most part, it is, and I think it's probably incorrect to say that it's been undermined. But that's convenient, because if it's been undermined, it allows them to adopt an approach to antitrust in California that diminishes the role of economics, that relies much more on structural presumptions, and not to be overly critical of Europe, adopts elements of an abuse of dominance standard rather than the monopolization standard we have now. All of which I think are efforts to suborn this repoliticization of antitrust. So let me just conclude my, you know, you're supposed to have remarks that have a conclusion that say, well, here's what we should do. And of course, there's no exact answer to this. I want to be clear that while I think economics is clearly the right approach, I do recognize that there is an inherent political valence to it, and that it doesn't jibe with other people's political preferences. I think there are very strong arguments why economics should in fact remain absolutely primary, in a place of primacy in antitrust. The threat to economics here is a little bit different than what we've been talking about with Cento, who has also pointed out that despite these criticisms, despite these problematic examples, generally speaking, economics still is in fact, and econometrics are central to cartel cases. So I'm sympathetic with the idea, but I think there are deep problems with the mechanism, not least because because those who would remove or diminish economics' role in antitrust determinations are almost explicit about wanting a regime that gives greater discretion than they currently have. We can talk about whether that's desirable or not, but I think for a lot of obvious reasons, it's not so desirable. And it seems like economics, which has great probative value despite its occasional problems, it would be terrible if that's sort of the casualty of this. It's interesting to hear people like Metter say we should have legislation that constrains the role of economics in antitrust. That I think would be a bad idea. There is also legislation out there that wouldn't directly restrain the role of economics, but that would create causes of action that I don't necessarily agree with, and that, like the DMA, wouldn't necessarily require any economics, but at least they're the product of I don't know, seemingly democratic process, I suppose, rather than just granting more power to the enforcement agencies. So I guess I'll finish with one final comment, which is to say that I think I already said that, so this is my second final comment. My second final comment is that I think it's troubling the sort of the evolution that's happening now, but I think it's even more troubling that there are many on the left, among the neo-Brandesians, who are very supportive of the sort of the latest America First kind of approach. As so frequently the case, political ideologies are very willing to give massive amounts of discretion to their opponents just so they can preserve it for themselves. And I think that there is a sense that there's alignment between these two sort of movements, and I think that's a real mistake. I think when the America Firsters start coming for sustainability and social justice, and when they start using antitrust to undermine free speech and the mainstream media and various other things as well, I think those who have political problems with that are going to have a problem with the amount of discretion that they've given to someone who isn't going to use it in the service of the objectives that they want to use it for. That's a classic problem.
I think this is a good time to open it up to a final Q&A, quick one, and we can continue the discussion. Alrighty, is there anyone who has questions? Let's hear from someone, and then maybe.
Thank you very much. Fernando Diez, law professor in Nebrija University. Geoffrey, I agree with you that yes, DMA, no need to ascertain domain effects. No, it's like, but here in Europe, we have our doses of more economic approach, all the debate after Intel, the latest guidelines. Don't you think it's more reliable a formally, legally based approach than, as we have seen today, econometric approach, which at the end of the day can say either one thing or the other? I mean, what firms need is predictability.
Yeah, well,
and that provides the law, the formally, legally approach as opposed to the more economic approach doesn't provide it?
As with so many things, I think it's an inverted U, and the optimal amount of formalism and discretion is not zero and it's not infinite. And I think another way to characterize what was great about the sort of, the economic revolution in antitrust was that it was in fact pushing back against excessive formalism and introducing an approach that was, was effects based. And yes, you can sort of, in a sense, go too far with that, as any adherent of error cost analysis would say. And as I said earlier, eventually the cost of processing and obtaining more information costs more than it's worth. So, there is another side to that but I don't think I certainly wouldn't say that we're in need of much more of, like the answer here is more and more formalism. I mean, I think the DMA is sort of a good example of how that's likely to go wrong. But I mean, there is of course a trade-off, and there is an optimal level. Yeah, I mean, I don't have econometric evidence though to prove that the spot where I would pick it is exactly right.
So the EU's rule-based approach and kind of not leaving much area for economics evidence, specifically in the DMA, do you think that this is a failure in Europe and it shouldn't be applied to other systems?
I mean, too early to tell, I guess. I mean, if I'm being honest, I mean, of course, I have those suspicions. I do think elements of the process that has been implemented actually go to show that no matter how rule-based your regime is, it's always going to be taken advantage of by interested parties, and rent seeking is always going to be a problem. The trade-off is the classic sort of trade-off between standards and rules. Rules are cheaper to adjudicate, and they're much more likely to get it wrong, and standards are harder to adjudicate, and you run into problems with conflicting econometric evidence, but you're more likely to get it right. And I mean, I guess it kind of goes back to the general arc of antitrust that I've been talking about. We don't know exactly, we don't have enough experience with the DMA to know exactly what's going to result from it. But we do have hundreds or almost 100 years of antitrust history before economics came along to recognize that was not a desirable period. I mean, some cases were correct, some cases were wrong, but they were all over the place, and they were not particularly rooted in anything other than the political preferences of the day. That seems clearly worse to me than a regime that looks exclusively or as much as possible at economic effects and makes decisions that way. But if you want to do politics, that's a terrible system for you.
Questions? Yes.
Thank you for the presentation. I'm Héctor Otero. I work as an economic consultant. So first of all, saying I'm very happy.
Yeah, right.
I'm very happy with with more economic approach. However, just I agree with all what you have said, but I think that you are missing two things maybe. That one is related to I mean, many things, but it's normal in a
2 hours, it's difficult.
But like in this debate of whether the far right, far left are trying to intervene in this, I think there is a missing point that is how we reach here. And I think that besides the fact of more or less economic approach, like the burden of proof and the standard of proof, it has been really directed to a more centrist point of view where maybe has prioritized and favor big companies in the sense of, okay, if you make a standard proof really hard, it's really difficult to prove that an abuse of dominance happened. Or at the same time, we say, it seems like right now we have a really important role of economics in competition, but at the same time, if you see, for instance, the concentration cases, you see that most of the concentration cases go through. If you go through the economic literatures, concentrations are bad in general. They're like, it's really weird that you build a model where concentrations are good as a general principle. And I think this is part of most of the critics that have come in the previous phase. It's true, I really don't understand the American first economics yet, but in the so-called new boundaries, there has been many critics that have been characterized as so, and what they were asking is, okay, if from the economic point of view, 90% of the cases, this is bad. Let's just not go through all the economic debate, because then the result is going to be the big one is gonna win. And I think the European Commission tried to do this. I think it did not. I mean, the idea was there, and I think it did not go through. So I don't think this was a missed opportunity to have stopped all these critics. Like all these problems that we have seen now, like I think we're having a fake debate on this, whether to put economics up or not.
Okay, so I do think that there's the things like the burden of proof and other procedural rules are extremely important. And certainly, I just wanted to focus on sort of the relationship to economics, which of course means a lot of things in a lot of different contexts in antitrust. And I agree to an extent that sorry, and I wanted to say that while people in both of these camps do point to things like saying we should adjust the burden of proof or adopt ex ante regulations, they also are very explicit about the harmful effects of economics. And I guess what I think, and simultaneously, and this is really your point, they think enforcers should win more. They think we should have a more enforcer-friendly, plaintiff-friendly regimes. Which you can accomplish by, for example, shifting the burden of proof or presumptions or things like that. So it's not inherently necessary, I don't think, to sort of attack economics to achieve, if that's your objective. I mean, the DMA, for example, it seems to me that you could have accomplished 99% of what the DMA did and still allow for something like an efficiencies defense. Still allow to, I mean, yes, you're increasing the cost of adjudication slightly, but acknowledging that there are in fact trade-offs, that there could in fact be, pro-consumer rationales and benefits of the condemned behavior, and accepting that, we can't do it perfectly. Instead, we have a sort of condemnation of that approach, and we have a regime that explicitly excludes an efficiencies defense. Or we have, for example, Mark Metter advocating for congressional legislation that would literally explicitly restrict the role of economics, whatever that means exactly, in antitrust. And that's what I think that's problematic, and I think that's a mistake, and I think it is unnecessary, even if you have some other objectives, but ultimately it will be far more costly than whatever benefits they think they're going to gain from it. And I'd rather see them shift the burden of proof. As much as I wouldn't agree with that, at least that's sort of straightforward and legal lever instead of an economic.
Okay, I think we've run out of time, but should we take one more question or?
Sure.
One more question? Okay, over there, I think you had a question. Quickly.
And Cento might want to weigh in on this too.
Yeah.
Economic analysis, because I would focus on the infringement of abuse of dominant position and collusive agreements, because I think in abuse of dominant position cases, the economic analysis may be more relevant, but less maybe with regards to collusive agreements. In particular, in EU law, we have this concept of by object restriction.
Sure.
So what do you think in this regard about, difference between both infringements, if there is a difference in the economic analysis and in particular with the by
It's
object?
interesting because all three of these questions are basically the sort of variations of the same thing, and my lodestar is Frank Easterbrook, and he very clearly said rule of reason is really bad and is going to lead to exactly these kind of problems, and we should have, well, he advocated for more per se legality rules than per se illegality rules, but both are simpler to administer, and they have their trade-offs. And I'm not opposed to in any way to a regime that adopts per se rules, especially if it did adopt more per se legality rules of per se legality in certain instances. and accepts that that means we will have some errors, and we can observe that, we can see them, and there's a sort of almost like nothing we can do about them, but that's because the overall system is more efficient. I don't have any problem with that. I think that the problem is with it just seems like it's too excessive to go to something like a DMA version of it. Having a competition and having competition laws that include some offenses by object, precisely because we've learned through economics that these are usually bad, and that it's generally safe to condemn them if you've met a certain couple of factual predicates. The DMA strikes me as something sort of, it's not like just a minor extension of that. It's something dramatically different. And, but I mean, it's only one small part of competition law, I suppose, and the rest of it hasn't really changed. And by the way, I think, Europe had its own sort of, movement toward a more economic-based approach. Somebody mentioned the Intel case. Obviously, the courts are getting a little bit are getting interested and think that a more prominent role for economics seems to be beneficial in some circumstances. I don't really have sort of the same problems I used to. Now, I guess it's just the Overton window has shifted. I used to think that, it used to be American antitrust law is so much better than European antitrust law. It does economics. And now European antitrust law sounds fine because we have the DMA, and that's the new enemy. So European antitrust law looks great. But
Cento, I don't know if you want to weigh in on this at all, or if we can just move on. Okay.
You don't want to praise European antitrust law?
I'm sorry we didn't have enough time for all of your questions, but the good thing is that both of our panelists have extensive writings on all of these topics. So you can either read them at the ICLE website or on Cento's website. And Lazar will now close off the ceremony. Thank you.
German novelist Ernest Younger said, when you kill God, the Titans return. And in competition law, economics has been closed to a God for a long time. Now, the objective of this conference, believe it or not, it was not just because Cento wanted to come and we wanted Cento to come, which of course we're very grateful for. It was also because there's currently sort of, maybe coordinated is not the right word, but there is definitely a situation in which economics is now under fire in ways that it wasn't 20, 15 years ago, even when I studied competition law 10 years ago. One thing that we've learned, I think, from today is economics is good at cabining enforcers' discretion. I think that the use of economics is not a plant. It's not some sort of ideological neoliberal plant, as some suggest, but it is the result of judges' quest for certainty. At some point, one of the claimants or a defendant raised the issue of economic evidence and said, listen, there's no evidence for what you're claiming. Prices have not gone up, or prices have gone down, or look at these efficiencies. And then the opposite part had to respond in kind if they wanted to win that case. Successively, we have come on to a situation where other more vague or abstract notions have come to be jettisoned, such as politics or some of the other values that Jeff mentioned, and economics has come to take its place. Of course, those who would want competition law to be more discretionary, to pursue different objectives, object to that. However, as Ernest Younger said, when you kill God, the Titans return. So the alternatives, which we have to consider, are not always better. They're often worse. If you think, as Jeff said, and I think as follows from Cento's presentation, that having 2 experts or 3 experts makes cases unmanageable, try introducing political, social, and other moral goals, such as some would. That would make it intractable. And we would effectively go back to the pre-ideological, quote unquote, era, or the ideological era of antitrust. So in a way, what I'm trying to say is there has to be a consideration of the nirvana fallacy. When you're comparing economics with all its failures and downsides, you can't compare it to some perfect utopia. You have to consider what the alternatives would be. If you have a moral standard or some other sort of political goal, again, how will that be measured? How will divergent goals be measured against one another? I think that judges, whether we want to believe this or not, I think judges don't like that much discretion. And economics provides them a tool, if when they understand it, to cabinet that discretion and to provide relatively clear-cut answers, right? Now, if we jettison that, we risk going back to an era where antitrust law was gaseous more than concrete. And I don't think that's necessarily good. So my overarching message, Jeff said that any concluding remarks have to include some sort of call to action, right, or recommendation. My recommendation is before jettisoning or sort of cutting out economics, from regulation, from competition law, we should consider what the alternatives are and what they bring to the table. And that's part of what we've tried to achieve here today. I would like to ask you to give yourselves a round of applause and to give our panelists a round of applause. Thank you very much for being here today.
And especially Sabrina, thank you for
And our brilliant
moderating.
moderator. Now, if you will join us for some post-event snacks in the lobby. Thank you very much.
Thank you.
Thanks.
Thank you.